Welcome to HR Minutes. I'm Tim Timmons, the HR Director at the South Carolina Chamber of Commerce, and we're glad you're visiting with us today. Today we have Mike Carrouth from Fisher & Phillips Law Firm with us. Mike, glad to have you here.
Thank you, Tim. Good to be here.
Mike, I was reading one of your legal alerts from your law firm, and it talked about President Bush having signed some ADA amendments last year. And just now, after a year, apparently getting around to the EEOC actually issuing guidelines to implement what President Bush signed. And I wanted to talk to you about that a little bit today. So if you don't mind, just, I'm hearing the potential is there for more claims of disability claims based on the EEOC regulations. Can you talk a little bit about that and what your thoughts are for me?
Well, Tim, that's definitely true. What the EEOC has done with these proposed regs is address the definitions that are key to the Americans with Disabilities Act, the definitions of disability and what it takes to have someone covered by the statute. And what they've done is broaden that so that it's much easier. In essence, they've lowered the threshold so that more people are going to be covered by the statute, which is going to mean that more employees are going to be covered, which means more employers are going to have to address issues with reasonable accommodations and potential litigation issues when someone says that what you did to me that I do not like was done to me because of a disability.
So you'll have more people eligible, and they change the definition, or did the definition change, have more people?
The changes in definitions were intended to make it a broader coverage.
So is the definition, is the major life activity piece still in there? What is a major life activity I've heard so much about?
Well, the core definition of what a disability is still the same. A disability under the ADA is a physical or mental impairment that substantially limits one or more major life activities. They did redefine what a major life activity is, and a major life activity is any activity that people in the general population can do with no or little trouble or restriction. So basically anything that any of us can do is now a major life activity. Sleeping, eating, going to the bathroom, reading, standing, anything that you can do as a human is pretty much going to be a major life activity.
Well, that's kind of broad.
It's very, very broad. And then they combine that with what does it take to substantially limit a major life activity. And what they've done there is say to substantially limit a major life activity, you have to have some type of impairment that prevents a person from doing that activity in a way that is less than what other people can do or compared to the general population. So if the general population is able to do that activity, but this individual, because of a physical or mental impairment, cannot, then that is sufficient to substantially limit that major life activity.
So it's not a matter of not being able to do the major life activity at all. If you have a limit in the amount of it or the ability to do it, that's interesting.
That's correct, and the regs specifically say that an impairment does not have to prevent a person's ability to do the major life activity or substantially limit their ability to do that or substantially restrict their ability to do that in order for it to be covered.
So how about things like, when you think about substantial limit, that's what's got me concerned right now. How about things like high blood pressure, carpal tunnel, those kind of issues we've done so much talking about? Would those be covered, or could they be covered?
Yeah, again, what the EEOC has done, what they're doing is the EEOC is basically telling employers, we don't want you sitting back in your office dealing with employees trying to figure out if their physical or mental impairment is covered by the ADA. So they've written these proposed regulations in such a way as to make it clear that almost any physical or mental impairment you have, high blood pressure, any of those issues that you mentioned are going to be covered, and they're listing them in there as being conditions that commonly or consistently meet the definition of a disability. So don't worry about it.
So when in doubt, it is covered.
That's right. The EEOC is basically saying we don't want you wrestling with the issue of whether it's a covered disability. We want you to get right to the reasonable accommodation aspect. We want you to start helping the people that in their mind they think you need to be helping.
Does this go back? I've also read something, Mike, and if I may be off base, if I am, just correct me. There's something called an automatic disability, and I'm not sure what that term means.
Well, that goes back to the point we were just talking about. Automatic is probably a term employment and labor lawyers use in sort of trying to analyze these regs, but that's where the EEOC is saying that these conditions are almost always going to be a disability under the ADA. So HIV, like I said, high blood pressure, things of those kind of things are almost always going to be covered.
Do you know if there's a list of what these activities are?
There are several lists there. Some of them are exhaustive, some are non-exhaustive, but they do have a list of those.
Probably find those online somewhere. We'll try to get that to our viewers pretty quickly.
We can.
Good.
Yes.
How about, I've also heard something called a perceived disability, where the person may not be disabled, but as I understand it, if most people perceive that person to have the disability. Can you talk about that a little bit?
Yeah, that can be a very troublesome part of the statute. That is not new. They've always had that as part of the definition of a disability. But the old rule, the old law would be that in order for an employee to say that they were discriminated against because of a perceived disability, they had to prove that their employer perceived them as having a disability that substantially limited a major life activity. So they had to show that their employer thought that whatever their physical or mental condition was, that it was severe, it was really bad. Now under the proposed regs, that they don't have to show that at all. All they have to show is that an employer took some type of action based on a perceived disability. So if you're have an employee with high blood pressure and the employer just says, well, we're just not going to put Joe in that job because of his high blood pressure, and they have no other medical information or data to say that it's severe or that causes a problem, that's all they got to show is that action was taken because of that.
And one more thing before we close this up, can you briefly, in like a minute, if you can, I know this is hard to do, can you go through the legal process for me in terms of a disability claim in South Carolina, the steps that would go through, like I think in South Carolina goes through SHAC, but can you run through real quickly what that legal process is should an employee file a discrimination claim?
Right.
How it would normally go?
Well, those are covered by the Americans with Disabilities Act, so you have to go through the administrative process with that. We do have the deferral agency in SHAC, but a large number, if not most of the disability claims are going to be investigated directly by the EEOC. Okay. They take, I think, priority over those and will be investigating those primarily. But you have to go through the administrative process, which means that even if you prevail at the administrative level, the employee will still have the ability to file a claim in federal court under the Americans with Disabilities Act, even if you do prevail.
I didn't realize that. Anything else you want to tell about, any kind of advice you can give us? I know it's like asking for cheap advice. Anything you can give us in terms of employers, what they can do to protect themselves? Yeah,
I think it's really going to be real important for companies to make sure that their policies sufficiently address issues with disability discrimination, that those things are considered, that they train all levels of management on what the new law is and how much broader the coverage is, and train all levels of management on what their responsibilities could be under the reasonable accommodation process. And for HR professionals out there, they really need to have a good handle on how to go through that, what the EEOC calls the interactive process. When someone comes to you and says they have a disability, what is the process you go through to sit down with them and talk about what that disability means, how it impacts them in the job, and how you're going to work with them to allow them to do the job, or in some cases determine that they can't do the job, and how are you going to handle it. The interactive process is going to be something the EEOC is going to look at very, very closely.
Mike, some of these things you're talking about to me sound like some employers are going to be out there changing some handbooks, some language in handbooks.
You could. That could be definitely what you need to do. Handbooks and operation manuals too.
Time to visit with your labor attorney and let him take a look at your policies.
That's always advisable.
Always advisable. Well, Mike, thanks a lot for being with us today. I appreciate it.
Thank you, Tim. Thanks for having me.